You've heard on several occasions that business organizations, and in particular corporations, are people. They have the status and some of the rights of living, breathing things. But of course, we know that since they are fictions and don't walk the earth with bodies, with hands, with legs, with heads, that in order for a corporation to actually do something, it needs to have a human being who acts on its behalf. It needs to have living, breathing agents. And corporate governance at its core is about agents, and it's about what it takes for someone to have the authority to be the hand or the leg or the head for this person known as the corporation. What does it take for there to be someone who is authorized to act on behalf of the corporation? In order to examine how basic corporate governance rules work, we're going to look at the case of our friends here at Utz Incorporated. Utz is the name of the company that was the subject of the discussion of the charter amendment process that you'll find in the textbook from pages 412 until 418. And we're going to pretend now that we're counsel for Utz. Instead of being an MBCA corporation, we're going to assume that Utz is a Delaware corporation. So we're going to focus on Delaware law, which is very similar to the MBCA rules. And we're going to ask ourselves, let's assume that Utz did in fact go through the charter amendment process that is described in the textbook, but now has identified an investor for the new series of preferred stock that it wants to issue, and for the financing it wants to obtain in exchange for that issuance. And we're asking ourselves, what more from a corporate governance point of view must the folks at Utz do in order to get that deal done? Okay. So we're in a world where Utz has already gone through the process of adopting the charter amendment that is discussed in the textbook, and we're at the next stage where we're looking at entering into an agreement between Utz and the investor. Okay. And to start with, I think we're going to look at this agreement. And what I've done is I've taken selected provisions from a form of securities purchase agreement, right? Where did I get this form? Well, if you search for securities purchase agreement in practical law, you will find a form that you will quickly recognize was the base for this form. And what I've done is I've just kept some of the more basic terms from the securities purchase agreement so we can see how a deal like this gets done and what the corporate governance implications are. All right. So here we see this is a securities purchase agreement. It's between Utz, which we've now made a Delaware corporation, and some as yet unnamed investor, probably a venture capital fund of some kind. And what is this securities purchase agreement about? It's about the issuance by the company of 1,000 shares of so-called Series Seed convertible preferred stock without par value, right, in exchange for a designated amount of money. All right, pretty straightforward. So I often like to begin in looking at documents like this at the very end, right, because there, I think, is where we'll find perhaps the most basic question that we're trying to answer from a corporate governance point of view. Look here. Right? What's the issue? Who gets to sign? Who has the authority to bind Utz? Right? Who has become the hand or the leg or the head, if you will, as we described earlier, to represent this fictional person in a transaction with this investor? Right? And how does that person get created, anointed, authorized, if you will? Right? Well, you'll see that that question is of course significant importance to clearly the investor who wants to know that it has a binding agreement with Utz, And so it gets talked about in many places earlier on in the agreement. And let me show you some examples. Right? Here, for example, is the representations and warranties that the company makes in connection with the offering. Now, what are these reps and warranties? They are assurances that are being given by the company to the investor that certain things are true, and that if they are not, the investor will have recourse against the company for any damages it suffers, right? So these are very important provisions. They tend to deal with all kinds of things, including things related to the quality of the company. But the most basic representations, and the ones that I've kept here for us to look at, relate to the question of governance. Right? So, for example, the company tells the investor that it is a corporation. Right? Okay, why is that important? Right? And that it's duly organized, validly existing, and in good standing under the laws of the state of Delaware. Right? What is telling us that this is a corporation that has been duly established in Delaware? What does that allow us and force us to do in terms of examining the questions of corporate governance? Right? Well, we know that if we look at the Delaware statute, that corporations formed in Delaware have, for example, the right under the statute to issue one or more classes of stock. Right? And it goes on to tell us what approvals it needs in order to do that. Okay? But the fundamental question of whether or not this person, known as Utz Incorporated, has the corporate power and authority to enter into an agreement that provides for the issuance of stock is answered by the fact that the Delaware statute says it does. Right? So that's why this phrase is so important. Right? Then it goes on to say that this agreement has been duly executed and delivered by the company, etc., right? And constitutes a legal, valid, and binding obligation of the company enforceable against the company in accordance with its terms. Now, where do we find the underlying substantiation for that statement? Right? How do we know that is true? What allows us as a company to make a promise like that? Well, we know that if you follow the rules of either shareholder or board approval, whichever is required in this case, and we'll examine what that is, and you obtain that, and then you authorize an agent to enter into an agreement for a purpose such as the issuance of stock that's permitted by the state of Delaware, you then have a duly authorized agreement, and it will be duly executed and delivered if signed and transferred by the agent that is named as having authority in whatever approval you get. Right? So again, these phrases refer back to the corporate law rules and the corporate law procedures around what has to happen in order for someone to have the authority to act. All right? Where else do we see concepts like this? Investor asks for, as part of the conditions to his or its obligation to purchase the securities being sold, right? So I don't have to give you my money unless the following things are true, right? So number one, unless we get a signed copy of this agreement, okay, pretty simple. But then on top of that, I need a certificate of the secretary certifying that all of the resolutions that relate to the approval of these documents are attached and that they've been duly executed, right? So why would you want that? That you're given a copy of the certificate of incorporation and bylaws. What are you looking for when you ask for those as a buyer of a security? And then the name and signatures. So in other words, a sample signature of the officers of the company authorized to sign, right? So what do you think these three things do for the buyer? Right? It allows them to conduct their own independent examination of the question of corporate authority. Right? It allows them to do due diligence on whether or not the governance rules have been complied with in order to have a valid and binding agreement, right? It's belts and suspenders, right? It's further verification of whether or not these statements, these warranties are truthful. Okay. Now, whether or not you'd insist on this every time because you are willing to trust others to provide you those assurances is a question, but it's not at all uncommon for a buyer to say, hey, show me all the pieces of paper that should make me comfortable in concluding that the person who signs this agreement had the authority to do so. Okay. What else do they ask for? Oh, well, obviously they want the shares themselves, but here they're asking for a legal opinion, right? And what do you think a legal opinion by the seller's lawyer, the issuer's lawyer, says as it relates to the issuance of stock under an agreement like this? Well, let's see. So here I'm looking at some practice notes that you can find if you search for legal opinions in securities offerings, again on Practical Law. And what these are descriptions of the various statements or opinions that are typically provided by the issuer's counsel in a securities offering. So exactly what this clause and the Exhibit B refers to, right? So this is a requirement that the buyer has, that the seller, in order to complete the transaction and get its money, has to give its lawyer's opinion to the buyer, and those opinions generally say things like, right, that the issuer is in good standing and has power and authority to execute, deliver, and perform its obligations. Does that sound familiar? That the agreement has been duly authorized and that there's been due execution and delivery of the agreements. Again, does that statement sound familiar? That once everything's done, they are legal, valid, and binding obligations. Does that sound familiar? And then finally, that the stock that's being referred to in the issuance has been duly authorized and been validly issued, fully paid, and so on when the actual purchase price is delivered. Okay. I would suggest you just take a look through this document and the descriptions of the different opinions, but I think you will soon find that they bear remarkable resemblance to the reps and warranties of the company. So again, belts and suspenders, right? Why is the buyer so insistent that it not only have the company's assurance that the agreement has been duly executed and is now valid and binding and enforceable, and that the stock is validly issued, but it's also asking for the documents themselves that establish that authority and due issuance, valid issuance. And then finally, it's even going further and saying, oh, go get an outside expert, someone with malpractice insurance, to give us the exact same assurances. Right? So as you can see in a securities offering, corporate governance is very much a central part of the process. Okay, so let's get back to our deal between Utz and our venture capitalist who's providing this $1 million of financing, right? And as we saw in the securities purchase agreement, the basic deal is the company at closing is selling to the investor $1 million worth of Series C preferred stock. So that's 1,000 shares at presumably $1,000 per share, right? Okay. And we saw that as part of that deal, there are several things that the company is going to have to do in order to get that done that relates to corporate governance. And in particular, we saw that there were a list of things the company had to deliver. One is it's delivering its performance, if you will, of these reps and warranties that address corporate governance. It's delivering a set of documents that embody the corporate governance actions that were taken in order to satisfy the corporate governance concerns of the buyer. In other words, to be sure that they have a valid and binding agreement and have validly issued stock. And finally, a legal opinion. Right? All of these things are designed to deal with a checklist of corporate governance questions. Right? Was the company in good standing? Is it in good standing? And does it have the power to do the things it's doing in this transaction? Has it taken the steps it needs to take to duly authorize the agreements? And then once it's done all those things, has it entered into a valid and binding agreement? Right. So those are basics. But I want to focus, for a second, on these two, right? And ask, well, what is it that our company has to do in order to make sure that it has satisfied these items on the checklist? So what does it mean to have duly authorized stock that's validly issued, fully paid, and non-assessable, and with no preemptive rights in the context of our issuance of 1,000 shares of Series C? Okay. Well, I guess the best place to start is here, right? The Delaware corporate law, which tells us that every corporation has the power to issue different classes of stock. And so if you were to read through this with some care, you'd learn that the Series C is probably a valid class of stock that the company has authority to issue. Now, we don't have in front of us all the documents we would need to do that. We would have to actually read the certificate of designation that's being adopted to create that Series C and compare it with the permissible terms under the statute. But assuming we did that, we would understand that this is something that's authorized by law, the corporate law, the statute. But we can't stop there. So how is it we know that UTS is allowed to issue a new series of 1,000 shares of preferred stock? Well, remember, we prefaced this whole discussion with the fact that UTS had done the charter amendment process that was described in the textbook, right? And that what it had done is change its certificate of incorporation from this provision that limited it to 10 million shares of common stock into a new charter provision that added the right to issue an additional 1 million shares of preferred, and that giving the board the power to issue that preferred from time to time with its rights and preferences designated by the board. Right? This is what we call blank check preferred. Right? And so in doing our work for now, the actual issuance, the actual sale to the investor, we would go back and make sure and recheck, although since we were the ones who probably did it, we wouldn't probably need to go back and redo it. But we check and say, oh, look, here's the original charter, but we have a filing that was done with the Secretary of State of the state of Delaware, right? Let's see. That says, hey, we've amended that charter and we now have the ability to issue up to 1 million shares of preferred in a blank check preferred provision. Right? And so we would make sure that this amendment had in fact been filed with the Secretary of State. And we would probably check to make sure that the procedures that led up to this amendment, including the requisite shareholder vote and board approval, would be in the minute books for the company. Right? But once we had gotten here and realized we have a blank check preferred, we now know that assuming, again, we comply with whatever restrictions there are on the terms that you can adopt in a new class of preferred, that we have the ability, we have the wherewithal, we have the sufficient authorized capital to issue this new class. How do we do it? Well, you've seen another example in the chapter of a certificate of designation. We spent a lot of time talking about it as it related to the quiz. And that's how you do it. You have a board of directors meeting, right? And I think it would look probably very much like this one, right? So done by written consent, where the board would get together. Query, does it have to be unanimous since we're in Delaware? You should look that up. And they would, by written consent, adopt a form that looks like the certificate of designation that we saw as to the 3% convertible that defines the terms of the series seed. And they'd adopt and they'd create 1,000 or more new authorized series seed shares, which would then be available to be issued to the investor. Okay, so if we found that charter amendment, if we found that board authorization, are we done? Well, no, because we have to look here, okay, and look at this provision. This says that in order to create a new series or class of stock pursuant to, and I'm paraphrasing, a blank check authority granted in the certificate of incorporation, which is what our charter amendment did, right? So if the board is creating a new series like the series seed preferred, you have to file the certificate of designation as provided in 103. And what that really says is basically you have to treat it as if you are amending your charter. Now, do you need the shareholder approval that you would need in order to file an amendment to your charter? The answer is no, right? Because this is a blank check preferred, the board is authorized to create these shares without further action on the part of the shareholders. But nevertheless, because the certificate of designation has the same effect as a charter amendment, i.e. it creates a new class of stock, it won't be effective until you file it with the Secretary of State. And so one thing you would need to make sure you are doing in order to be able to give this opinion is you have to find a duly filed certificate of designation that specifies the terms of the series seed. And no surprise, right? What's one of the things that the buyer is very interested in seeing as part of its conditions to closing? The company shall have duly adopted the certificate of designation, which shall have been filed, right? Because otherwise, you're not buying validly issued stock. Okay? Okay, and you can't deliver this opinion. All right, what else do you need to know? Well, if it's been duly authorized, i.e. you found the blank check preferred, what we already knew about it, the authority in the charter, and you find the board action that in turn authorizes the certificate of designation, and you find that the certificate of designation has been filed appropriately with the Secretary of State, well, now we know we have 1,000 shares to issue, if that's what the certificate of designation says. But what makes those shares validly issued? Well, first of all, they had to be authorized, but then they have to be issued on terms that are permissible under the statute. And what do I mean by that? Well, if you look further, there's a whole provision that talks about what the requirements are for valid issuance and for stock to be fully paid. And basically, it requires that the board specify in the resolution approving this issuance what the consideration is for the shares and how it has to be paid. And in particular, if it's a series of stock that has a par value, there must be at least a price equal to the par value. In this case, there is no par value, so it can be whatever the board has determined, right? So in your written consent, when you adopt the certificate of designation, you are likely also going to adopt a statement about what the price per share, in this case $1,000, is, and how it gets paid, in this case cash. One of the reasons why it might be more complicated is if, let's say, you are issuing shares in exchange for services or for the delivery of assets of some kind, intellectual property, what have you. Well, then you would go into more detail in your resolution by the board as to how it is it determines what is a fair exchange for the issuance. But as long as you have those provisions, and in this case it's easy, it's $1,000 in cash, then all you know exactly what to look for at the closing, i.e. the exchange of one share for $1,000, and you are able to give this opinion or give this representation that the shares were validly issued, fully paid, and non-assessable. We'll leave preemptive rights for another day. All right. But I think the real point here, and again, we would have to go through a very similar exercise in drifting our way through the charter, the statute, the bylaws, and then the actions of the various bodies, whether it's shareholders or boards of directors, in determining whether or not we can give these opinions. But the important part is to realize these are all, you have to make your way through all of it, wind your way through both the statute and the corporate documents to make sure that you can come to a conclusion that the person who signs here, right, is doing so only after all the steps that corporate governance requires have been completed.